Hi, it's Ron Coleman. I want to talk about a free expression and trademark issue, and it has to do with disparaging trademarks. You might think that by now we've said all there is to say about this, and to some extent you'd be right, but I want to talk briefly about how I am a prophet. Prophet is frequently wrong, but this time I was right. The issue, of course, is disparaging trademarks. And I say, of course, because everyone watching this knows that I represented Simon Tam in his successful attempt to get a trademark registration for the name of his band, The Slants, which the Supreme Court of the United States ultimately held he was entitled to because the statute which prohibited disparaging trademarks was unconstitutional under the First Amendment to the Constitution as a free speech violation by the government because it was not viewpoint neutral. I wrote a blog post in May of 2017 on my Likelihood of Confusion blog, and I mentioned that someone who I respected, and who I still respect, asked me, well, if you win, what's going to happen? There are going to be all these terrible trademark registrations, and the world will come to an end. And I noticed a few things. One of them was that there are already a lot of terrible trademark registrations. There were then, there have been for many, many years. The novelty of spending a few bucks on registering a gross or offensive trademark is going to wear off pretty fast, especially because you have to use the mark in commerce. You can't just get a trademark registration. You have to use the mark in commerce on a product or service. Second, you have to put a name and address on a trademark registration, at least a lawyer does. The location of the business. Really, we're not so fragile. We can handle this. Trademarks aren't ways to own clever phrases or slogans. Just plastering a rallying cry on some garbage, on a tote bag or a t-shirt, doesn't make it your trademark. It has to be a trademark use, not an ornamental use or an expressive use. Careful with expressive use. I argued, not as forcefully as I would have wanted to in our brief because my team overruled me, but one of the things I wanted to make a point of in the Supreme Court was that there is no distinction between expressive use of a phrase and commercial use of a phrase or trademark use of a phrase. They're all one and the same. Trademark and commercial use of a phrase or a logo or any kind of trademark. All of these are expressive. Expressions, commercial associations with a trademark, brands as we call them, are expressive. They cause you to think of a certain concept. When you think of Cadillac, when you think of Mercedes, when you think of Volkswagen, you have an idea of what that brand represents to you. Is it champagne or is it soda pop? That's a form of expression, and the fact that it's associated with commercial transactions is a separate point, not unrelated, but not mutually exclusive. My point, though, in this blog post was that ultimately harbor registrations, as I call them, are garbage. They're not good business, and they're not going to end up dominating trademark law or the trademark register. Not only was I right, I was more right than I ever dreamed. The main reason anybody even really cared about the In Re Tam case, as it came to be known, the Slants case, wasn't because of Simon Tam or Ron Coleman or John Connell or any of the other people who worked with me in that case, Joe McMull, of course. The reason people cared was because of the Redskins, the Washington Redskins, the NFL team in Washington, D.C. that called itself the Redskins and whose own case was working its way on a parallel track through the United States Patent and Trademark Office. We saved the Redskins, and the Redskins kind of helped us save them. I've made this point every opportunity I could, although there were some moments of tension between us and the Redskins. They ultimately, through their counsel, helped us a great deal with our case because it was in their interest to do so. We saved the Redskins trademark, and within 5 years, the market made them change it. not the Patent and Trademark Office, not the Eastern District of Virginia, not the Fourth Circuit. The market, not only the market as reacting to all kinds of pressure. Nonetheless, the market it is. And I criticize cancel culture. I think there's much to criticize there, but I do not deny that it is, although it's not a pure market because of the power of corporate and technology, monopolies, network effects, if not monopolies, certainly disparate or inappropriate levels of market control, a lack of true market choice, government policies and laws and funding that favor certain players. It's not a free market in a meaningful term, but it is nonetheless the market. And the market decided to cancel the Washington Redskins. The market decided to cancel Aunt Jemima and Uncle Ben and everything. Just about everything that's interesting, right? They didn't need the government to do it. I don't like cancel culture. But I don't mind companies making decisions that are in their interests because they have to answer to consumers. They have to answer to stockholders. They have to answer to whatever constituencies they value for purposes of their business, to change brands. That's their decision. By keeping that decision out of the hands of bureaucrats who have agendas that have no accountability to them whatsoever, which was what had been happening in the Patent and Trademark Office. A culture had arisen that made it impossible to even consider appeals of legitimate claims that trademarks were not disparaging because of the political atmosphere and the fear of making an inappropriate registration, inappropriate from the political or woke sense, as we would say now. That's not the government's job. These are problems that we have to face ahead, but at least we got one agency out of the business of deciding what brands and what ideas can be part of the market of ideas, commerce, and human experience. Now it's up to you to make the brands, register the trademarks, and if necessary, to withstand the political pressure, if it makes sense for you to choose a brand that is going to be amenable to political pressure, through the market, not through the state. I said that that's what would happen and that's what should happen, and it is what's happening. And I'm going to take a little bit of credit for it. Thanks for listening.